The panelists for the third session will address complex problems involving rating permanent disability for neurological injuries. This panel will include Mr. Julius Young, Mr. Richard Montarbo, and Annalisa Becker. Mr. Young is a partner with the firm of Boxer & Gerson and a certified specialist in the field of California workers' compensation law. Mr. Young has devoted over 4 decades to representing injured workers and is an active member of the California Applicants Attorneys Association and a frequent presenter at various legal conferences throughout the state of California. Joining Mr. Young is Mr. Richard Montarbo, who is also a certified specialist in the field of California workers' compensation law with over 25 years of experience representing defendants in workers' compensation litigation. Mr. Montarbo is the architect behind Current Issues Workers' Compensation Conferences. Mr. Montarbo is the author and assistant editor for the Workers' Compensation Index, a topical guide to the law of workers' compensation, a LexisNexis publication. Richard Montarbo is the app designer of the CompCalc, the first workers' compensation rating and indemnity application for mobile devices. Richard is also an adjunct professor at the University of the Pacific McGeorge School of Law. Ms. Becker has been the Northern California Area DEU Rating Supervisor since 2004 and has been with the Division of Workers' Compensation for over 31 years. Ms. Becker was a past member of the PD Schedule Revision Committee, past member of the California Board of Legal Specialization Workers' Compensation Law Advisory Commission, and State Bar of California Law Executive Committee. Our panelists for the next session have just begun.
CompCalc is also available right now for your desktop computers, as long as you're smart enough and into technology enough to have Apple. So at the App Store, I'm just going to turn this on. Oh, you know what I need to do? How do we minimize this so I can see it? Well, I'll just show you up there. Right there's the opening screen of the CompCalc on the laptop. If you go to View, we're going to flip these, and here are all of your occupations, all your inputs. And it works just like the CompCalc on the iPad or iPhone. So it's available right now at the App Store for OS, which is your Mac. And here's the big announcement. I've been working on one more version. Well, in 2016, I'm gonna add the COLA calculation to life pension and to 100%. Right now, if you dial up 100%, has everybody done that? Dial up 100% on your CompCalc on the PD manual, on the PD, and watch what happens. And you have to understand that I am a defense attorney, so there has to be some humor there. Watch, I'll show you it on this.
That thing that runs across the screen, because I did that already.
Here it is. Watch what happens. I'm going to do it so everybody can see this. I'll do it on here. Watch the screen now. Okay, no, everybody thinks that's a horse. It's not a cutting horse because I'm into cutting horses. That is, and I'm a defense attorney, that is the 100% applicant. It's a unicorn. There are no 100% cases, and so that tells you that there aren't any. Anyway, but look at it changes, and it's a present value calculator. What you want to do is put in the discount rate in quarter percents. You want to put in the date of injury, the age, and the gender, and it will automatically calculate for you the present value of that future stream of income. Now, what is not here is the COLA calculation, because what the discount rate takes away for the defense attorney, the COLA calculation puts in for the applicant's bar. And originally what I was going to do was just say, well, listen, subtract the COLA from the discount and then apply that, and you'll have an accurate present value of 100%. But then I played with the numbers, and what I realized is the way you do this calculation can have a significant impact on your end number. I think the proper way, and Annalise might want to address this, but I think the way I'm writing it right now, and I haven't told you this, Annalise, but the way I'm writing it is the first thing that it does when you put everything in is it calculates, and this you won't see it, it'll happen like that, right? The number will just pop up. But first it calculates the COLA calculation. Then it applies the discount rate, bringing it back to present value. And I think that's probably the correct way to do the formula calculation. We should address, Blair McGowan and I are going to be addressing the people at CAW on this issue on 100% life pensions and COLA calculations in January. at the COG conference. So we'll see if I'm right on that, but that's the way I'm writing it. So for 2016, the CompCalc is going to have all the 2016 figures. It will also have the COLA and present value calculator for life pension. Right now it's only on 100%, as well as awards of total disability. So you won't, and what I would tell you is there's no way to write this code so that if you don't have a start date and an end date, a start date absolute, that you can be 100% accurate. If you send this out to an economist, he's going to take the start date and he's going to be very specific. What I'm doing is this is really for negotiation, and you should be within $1,000 of the end result with my calculations. So, and you'll be able to say what if. That's the nice thing about it. Also, I want to tell you something else.
Can I ask you, how is yours going to, you've seen the MedLegal calculator on their site. How is yours going to differ from theirs?
You know, I couldn't pay for a better question. Here's what I would say. You have to try both. That's me being fair. And pick the one that you like the best. Okay? Number one. Number two, if you have an app that in the middle of it shuts down and exits back out, that app is not correctly functioning. Because whether you're using Java in a Android environment or Objective-C in an Apple environment, that shutdown is a save mode. It's saying, holy crap, we just crapped out here, and it takes you back out of the app and takes you to the desktop. So if my app does that, but if somebody else's app does that, okay? The other thing I would tell you is this is a true app. There are other vendors out there that say, hey, download our app, and what they do is they give you an icon, and the only time it works is when you have internet. And that does two things. It slows it down, it makes it unstable, and it causes crashes. So the last thing I would tell you is I use pickers and rollers, and everything's quick, and it's in there, and it's relational databases. Plus I put, if you tap for detail, I put information from my book in there, further resources. My date calculators are different. On the TD calculator for a given period, it does it correctly, it calculates it correctly. If you look at a whiz wheel, it may or may not. You may be a day off, and here's why. Temporary disability is supposed to be calculated how? You include the first date, you exclude the final date, the last date, okay? That's what my calculator does when you calculate the temporary disability rate. The other thing that I would tell you is that if it's important, if you're going to use the average weekly wage, to do it in sequence. You saw me go back at the end to recalculate it on this, but the average weekly wage, to be correct, you have to have that date of injury in there when you start out. Why? Because the way I wrote the code is it's checking your average weekly wage when it does the calculation for what is the max and what is the min. And you'll see this. It never goes above the max given the date of injury or below the min. And then it calculates it out given the weeks, right? And it automatically generates that for you. See how complex, you have no idea, ladies and gentlemen, how many times I sat blurry-eyed saying crap, okay? Anyway, so we're going to have it in Windows. We've got it on OS right now. We've got it on for the Mac computers, and we'll have Windows. Hopefully, we'll be in beta testing shortly. I feel pretty confident that my database. Realize I have a relational database. You know what? I just teach a class on programming. I'm not going to do that. Anyway. I feel comfortable with the database, I feel comfortable with the calculations, and I think it's a real neat resource because it's quick, it's accurate, and it's stable. So that's the big difference is you don't have to have internet connection, and mine doesn't shut down. Not that anybody else's out there does, but mine hopefully won't shut down on you. Also, can I tell you something? If you find something that that you say, well, hold it, I'd like it to do this, or, Rich, it didn't do this. Like I got a text from somebody that was saying, hey, your average weekly wage went above the max, given the date of entry, and it's because she misapplied everything. She went back and I said, do this, and bam, oh, she goes, oh, I need you to tell me, go through this with me. okay? But it's all logical. If you go from top to bottom and then you go back and do what ifs, it's gonna calculate it for you. But if you find something, God help you. Now, God help me, if you find something that you think is not accurate or needs to be changed or you don't understand, like that flip. I had somebody write a review. Somebody downloads this and writes a review, and they post it. If you have a review to write, be man or woman enough to, hey, Rich, this is what I'm seeing. Be that kind of a person. This person wrote a review, and of course we don't know who they are, and they say, this is what they say, it's still up there, because I can't take it down. I'd give it a 5 out of 5, but I can only give it a 4 because I don't know how to input occupation. And I see that and I go, who is this person? So I called up somebody else and I said, hey, can you write a review? Because I can, I'm the developer. And they write it and they say, listen, all you have to do is go to YouTube and watch the video. You tap to flip. If it says tap to select or you have a field you want to tap, if you're not sure how to get around, just tap and see what happens and watch the way it is before and watch the way it is after, because I don't want to be a support person on this. This is just a cool app. And what's the price on this? You guys are getting it all for free. But the basic version, which is just the slide calc, is 99 cents. I mean, come on, folks. How many phone calls am I going to take for 99 cents? It's $4.99 on the iPhone. It's only $10 on the computer. I'm not doing it, ladies and gentlemen. Like it, hate it, whatever. Okay, so that's all I'm going to say. We're not going to revisit this. I'm shutting down this part of it. If you have a question or comment, Annalise will be willing to take those. I'm going to turn it over to her.
Hello. Good. Okay. So hopefully after this long morning and a yummy lunch, you won't be nodding off. And if you do, I will be watching you. So there may be some embarrassing calling out moments of, okay. Anyway, I'm Annalisa Becker. I'm up at the Reading DEU, used to be in San Francisco for many years. And I'm going to talk to you a little bit about rating, current issues that we're seeing, and touch a little bit on some of the case law that both of these wonderful gentlemen were speaking about and what we would do with DEU on these things. So talk a little bit about the effects of SB 863 on permanent disability, the effects of case law, a little bit on Blackledge, Guzman I'll touch on, and then some rating issues for orthopedic, neurological, and pain ratings. These things here we'll just touch. Labor Code Section 4660 for injuries on or before January 1st of 2005. We would use the 1997 schedule for rating permanent disabilities, and actually, amazingly enough, I still see about 3 to 5 pre-97 schedule ratings each month. And so they don't ever really go away. They just kind of linger until nobody else wants to handle them or something happens. But actually, a couple of months ago, I rated a case where the date of injury was 1962. The injured worker was injured their first year of working at this company. His entire career was at the same company. He's just retiring this year, so they're settling the case. Nothing major, but all of this time it lived. So they do walk among us. For cases that's pre-1/1/2005, we still use those older schedule ratings, so that's work restrictions, objective, subjective ratings, and so they're still in effect. For the injuries from 1/1/2005 until before January 1st of 2013, we're using the 2005 schedule, the AMA guides, 5th edition only. There was always talk about whether we would use the 6th edition or any other edition. And there was something brought up earlier today where one of the doctors was trying to do a rating based on the 6th edition. That's not appropriate. In California, we're mandated to use the 2005 schedule and the 5th edition of the AMA guides, and that will not change unless they change the law. So it will be the 5th edition for the AMA guides. Oh, it does say that the PDRS should be amended at least once every 5 years. That means we should be on our 3rd edition right now of the schedule, but, I guess we missed those two. Or I wasn't in on that meeting, apparently. So we have the 2005 schedule. We should have had actually in 2008 or 9, they came to us and asked us for our suggestions on what we would do to upgrade, and then they let it sit there and it never happened. So as far as I know, I do know, they're still sitting on my desktop on my computer. No one's asked for anything, but the only thing that was changing is for the dates of injury of January 1st, 2013 is now we do not use the future earning capacity adjustment, and it's a 1.4 modifier, and we'll talk about these. So we go back, though, from the 2005 schedule and the those dates of injury before 1/1/13, where we were talking about the nature of the physical injury. We use the AMA guides. We'd have the future earning capacity adjustment. But now with the 1/1/13, they're kind of going back the philosophy of the nature of the physical injury or disfigurement, the occupation of the injured employee, and his or her age at the time of the injury, but you'll notice that there is nothing about the FEC adjustment. So we don't have the future earning capacity adjustment. They have a modifier that they call it, and that's the 1.4, which is a 40% increase. There's a change in the PD weekly rates for the January 1st of 2013 and 14 cases. They've eliminated the up or down of the 15%. I think I'm speaking quickly. I had to I felt the need to have like one of those 4 shots of espresso drinks over there just to listen quicker to you because you were so quick. So I'm trying to calm down, but I'm still on my little espresso high of trying to listen.
I don't speak fast. Hey,
Yes,
I just had one question. The DU, I noticed, has changed the rating string on a post 1/1/13 with respect to the DFEC, the format. First of all, did we incorporate that in the comp calc, and what is the change?
Why, yes, it has been incorporated into the ComCAT.
Because she brought it to my attention.
Yes, I did bring it to his attention. And so what we have said, because the schedule itself has not been updated, so what could you do to easily know what is going on as far as 2013? So instead of having the FEC of 1 through 8 rankings, we, across the board, every body part has a modifier of 1.4, so it would be as if you were looking at rank 8 in the old schedule. However, let me go over here. Here's what the new formulas would look like. We have a taxidermist. I was inspired to use that occupation since we have a big game hunter here. And
okay, let's see. If you have the comp calc, let's just see if there even is a taxidermist. Whenever I did not check all of her rating problems, but what we can do is see if there's any errors in the database that makes up this. But anyway.
Are you going to check my rating?
I think everybody out there is.
Oh, okay. Well, so for pre-SB 863, a right elbow range of motion rating, we would have the formula. These all look the same. You're familiar with this. The impairment numbers for the body part, 16030100 would be for range of motion of the elbow. 7 would be the standard whole person rating. In those brackets is the 2. That's an FEC, future earning capacity adjustment of 2, which increases the 7 up to 8 whole person. And then for the occupation of a 311G, 8 becomes 9, and for the age of 54, it's an 11. For dates of injury on or after 1/1/13, it would be the same, except instead of the modifier for the future earning capacity of a 2, we have the increase of the 1.4. So all body parts will have this modifier of 1.4, which is a 40% increase. And regardless, again, of the body part, you're going to see these 1.4 modifiers for dates of injury on or after 2013. And it then adjusts, the 7 goes all the way up to a 15. And that's based on this modifier. And did anybody check to see if that's what
Well, the
happened?
problem is it's 54 years, and you have to subtract 54 from the date of injury to come up with, you have to put in the date of birth.
Oh, I'm sorry.
Because we only have date of births out there. Nobody gives me the years, right? But here's the other thing I wanted to point out. If you look at the old multiplier is 1.1, that's going to take a 7 up to an 8, because 1.1 times 7 is 7.7. You round it up to an 8. But a 1.4, that jumps it all the way up to a 10. So one of the things I pointed out to my clients is post 1113, a 50 becomes a life pension. A 70 just about becomes 100% whole person impairment. That's the difference in the modifier on with a lot of occupations now. So anyway, I'm sorry, DFECs now.
Other changes with SB 863, there is no increase in impairment ratings for sleep, sex, or psych disorder, or any combination thereof arising out of a compensable physical injury. And what that is, if you have an orthopedic injury, a low back rating, and there would be potentially under the pre-2013 cases, you might have someone that would have a sleep dysfunction. They'd give a rating under Table 13.4. They would have potential sexual dysfunction, where they'd have a separate rating for that, or a psychiatric impairment. Those cannot be rated under the SB 863 changes. However, they can be treated. There are exceptions to this, which I will talk about, but one of the things that you want to remember is sleep and sex. Those are activities of daily living, we hope, and so those can be increased in other ways. An injured worker can still receive the treatment for sleep, sex, or psychiatric disorder, but they would not be rated. And again, as I said, there's an exception to that rule, because there always is with the AMA guides. A psychiatric disorder may be rated if it's either the injured worker is a victim of a violent act, or direct exposure to a significant violent act, and then or a catastrophic injury. However, they speak about catastrophic, but they don't specifically define that, so it's kind of open to interpretation, and we'll be seeing that the way cases start playing out.
Why do you think, so far as I'm aware, there's no case yet that's really defined what catastrophic is? Is it catastrophic in terms of how the event happens, a window washer falls off of a scaffold, as opposed to someone trips and falls and gets an infection in their toe and has to have their leg amputated? I mean, there's no court decision on this yet, is there?
No, nothing's been litigated on this, and I think it goes back to what I said originally. The denial of psychiatric absent, catastrophic, or victim really doesn't change much of anything, because we still have to pay for the medical treatment. The catastrophic only does away, arguably, with the need to get a medical, if we can argue that. But this is what I say. Catastrophic, I think you look at three things. I think you look at the mechanisms of injury, the resulting treatment, and the resulting disability. If you take a look at Labor Code Section 4660.1, they only describe the last one, the disability. But I think if I was defending it, I'd want to look at the mechanism of injury, I'd want to look at the resulting treatment, and the resulting whole person impairment or disability. On the issue of getting a medical report, a case just came down this past year, or this past month. You might want to write it down. It's a Hernandez case. It's at 215 CalWork Comp PD Lexus 470. That's 215 CalWork Comp PD Lexus 470. What happened here was they had a psychiatric claim pled as a compensable consequence, and the applicant wanted to get a medical, and the defendant said, no, it's not catastrophic. And the issue was, does the applicant get a medical? Well, of course the applicant gets a medical, because you don't know if it's catastrophic until after you get a medical from a psychiatrist and or have him evaluate, because that's part of the puzzle, isn't it? I mean, they have to say whether or not it's catastrophic. And presumably, they would look at all three of those. They'd look at the mechanism of injury, the resulting need for treatment, and the ultimate impairment. I think I hear people argue, of course, the applicants want to look at whatever's the best, probably the treatment and the resulting impairment. We would want, on the defense side, to focus primarily on what? The mechanism of injury, and then possibly the resulting impairment. But
What is, in that case, were they able to get the medical?
yeah, the court held that they were entitled to that for the rationale that I just stated. The applicant gets the medical legal because that's part of their burden, and they're entitled to establish whether or not it's a catastrophic injury that gave rise to a psychiatric injury as a compensable consequence.
But ultimately, do you think, just posing the question because I don't know the answer, is it really for the judge, the trier of fact, to determine if it is catastrophic? What if I was approached by a psychiatrist recently, asked me for my opinion on this, and we discussed the same issue. What if the psychiatrist says he doesn't know if it meets the catastrophic definition, that's for the trier of fact? Is that
Well, I'll tell you what
who is the decision making, the judge or the QME?
I'll tell you what the applicant attorneys do. They turn to the Social Security Code, as I recall. There's the only definition of catastrophic in there, and it's a really high standard. It requires, and I may have it in my materials. I gave you stuff on this, but my recollection is that it requires that the person have a significant impact on their ability to do work. Significant or substantial, something along those lines, and the site may be in there. But what I think is, honestly, psychiatric injuries have gone the way of the dinosaur. Their value is more along the lines, I think, for treatment, and I think you do get a medical.
And what DEU would do is, if you're coming in with those medical reports, we would go ahead and rate them, but the rater should be making just an annotation discussing this issue that, per SB 863 or this portion of the labor code, that it would not be rated necessarily, but that's really up to the parties and to the judge at that point. We already discussed Labor Code Section 4662, and that Alvarez still applies under SB 863. So the Labor Code Section 4662, that was already dealt with. Apportionment, we talked about Benson. I'm going to go through some of this a little quicker because I want to really talk about and spend time with the actual ratings. So we'll go through here. I did want to talk about blackledge, and the reason for that is, how does that affect DEU ratings? And the question would be, is this case came through and it was meant for, or originally done because of a formal rating instruction. And so our question is, as raters, is does this only apply to formal rating instructions, or does it apply to all cases? And so that's why with ratings, you'll see a lot of annotations, or you should be seeing a lot of annotations on the ratings to make clarifications or things that we might see that are red flags, but we're going to provide those different ratings to you because if blackledge does apply on other cases besides formal rating instructions, we want to make sure that we're just reviewing the medical report one time and providing a rating for the parties with all of those different aspects. But blackledge talks about the role of the doctor, judge, and rater, and it goes really deeply into what the physician's role is. They have to assess the injured worker. They perform an impairment evaluation and what it should include about the history and the tests and the diagnosis. And with AMA guides, it's specific under certain chapters in the AMA guides that in order to make a diagnosis, you need to do certain tests. So those are really important things to know. For instance, if you have arthritis in a knee, well, how are you going to know that? You need, in order to make a rating, a diagnosis for arthritis in the knee, unless you have x-ray vision, you need to have standing x-rays. And that way they're able to see inside the knee and make those measurements in order to make the determination about how much joint space narrowing there is. So doctors need to know the chapters of the body parts that they're rating, and really you guys should be aware of those things too. There's certain impairment ratings that in order for the doctor to make a diagnosis, they need to perform certain tests and then discuss that in their medical reports. So again, all of this is still going on. This is all roles of the physician and how they write the report and how to make it a complete report and substantial medical evidence. And then the judge's role is to frame the instructions based on substantial medical evidence that specifically and fully describe the whole person impairment to be rated. In addition, the WCJ's instructions may ask a rater to offer an expert opinion on what the whole person impairment should or should not be. Okay, so they can ask us these things, but they spell out all of their decisions into this formal rating instruction. However, I will tell you, and maybe some of you have witnessed this, we get judges' instructions that will say, rate Dr. Smith's report for the low back. And that basically is leaving the rater up to pull all the information out of the medical report as to what is or is not rateable. And why is that a problem? Because what if the information that's in that medical report is really not rateable? Or what if they say, rate Dr. Smith's report, and that report has both AMA and Alvarez? Which one do we rate? It's really up to the judge to make those decisions. Those are things that need to be spelled out. Under the old schedule ratings for formal rating instructions, the only thing a rater could look at in a medical report were the objective findings. The judge had to describe any work restrictions to be rated or any subjective complaints of pain. It's not been decided if that's changed at all for the I don't know actually that it's been commented on under the labor code as far as AMA ratings, but if all we're allowed to look at is objective findings, there's a lot of stuff in AMA that's activities of daily living, the pain add-on, those are things that potentially could be added. And so what I see as a rater is the number of formal rating requests that I have gotten has dropped. The number of cross-examines I get is just a wee portion of those formals that I get. I probably have been cross-exed twice this past year, and I usually would be cross-exed maybe 10 to 15 times. So that is something that I'm thinking the parties don't know. If they're not able to settle and the case is going to a judge for formal rating instructions, I'm questioning why not. They need to get the medical reports rated as consultative ratings before it's submitted to the judge. So those medical reports should be rated ahead of time. And if they're not being rated and it goes to the judge to be submitted, then that whole file is going to be turned over to the judge to become the fact finder in what things need to be identified for rating purposes. So then the judge will send us a request for rating, a formal instruction that may simply ask us to look at a certain doctor's report. Or in some cases, they'll tell us to look at all 5 of those reports from the doctor. And then we're really getting all of this information. It's not being defined as the judge being the fact finder any longer. So that's an issue that we have. Then under the rater's role is to recommend a permanent disability rating based solely on the judge's formal rating instructions. Unless specifically instructed to do so, a rater has no authority to issue a rating based on the rater's own assessment of whether the whole person impairment referred to in the judge's instructions are based on substantial evidence or are consistent with the AMA guides. That's a problem. Because, as I said, we're getting some rating instructions that leave it very open to the rater to determine what those permanent disability factors are. And then we will become cross-exed on that, maybe, or not. And at that time, then your response to the rating is, why did you rate, response to the question, why did you rate this a certain way? Well, based on the judge's instructions, they said this, and it just leaves it very open. And in some instances, they've reopened discovery and put the case back to the parties.
Could I ask you a question? What are the proper issues for cross-examination? I think there are 3. What would you say? You want to know what I think? I think the only questions that you can ask a rater are, number 1, how did you rate it? Number 2, what did you rate it on? And number 3, should it be rated differently? That's all you ask at a cross-ex. I have people, I've sat through some of these cross-exes, and I just sit there and I scratch my head and I go, what's the point? You're trying your case here. That's not the issue. The issue is, what did you rate? How did you rate? Why did you rate? That's just it. And then it's up to the judge to understand whether or not it's correct or right. Can you rate it a different way? Those are the only questions you ask at a cross-ex. What do you think?
I think that's probably appropriate. I know a lot of times they'll go into hypothetical questions and then they go way off on a tangent, and I'll do with my experience of rating since 1988, I'll do my look at the judge. Like, do you really want me to answer that? And then they'll, could you rephrase that, please? Or, I'm not sure if I understand the question. Can you please repeat that? And then they'll rephrase it to something that makes sense. But yes, those are my...
I think there may be cases where, as an applicant attorney, you might want to cross-examine the rater if the rater used the combined values chart and you were trying to make a kite argument as to that the more appropriate way would be to rate it by adding rather than using the combined values. Maybe it wouldn't get anywhere with the rater, but at least you bring the issue up with the judge and then make a motion to strike the rating to substitute a different way of analyzing the matter.
That's possible. Yes.
Yeah, because the F&A hasn't come down yet. I believe I run my life the 80-20 rule. You have to know 20% of the information, or you use 20% of the information 80% of the time, but you have to know 100%. The other 80 you use on occasion, or you have to know where to find it. And that's why I have all these rules on how you should approach it. And that cross-ex, and I don't do, I told you, I just don't do it very often, but I've sat through them where I just shake my head and I go, I guess I should bill my client for this, listening to this.
On this particular slide, the second bullet point is, what if the physician incorrectly applies AMA guides or the schedule? And that's very common for things like that to happen. If the rating or the medical report was brought to us to be rated as a consultative rating ahead of time, then we could be pointing out all of these potential red flags, things that need to be clarified. Maybe you'd still have time to do a deposition with the doctor, or at least, ask by letter what some of these responses might be. But this is very common where the doctors will incorrectly apply the AMA guide. So for instance, you have a lower extremity rating where maybe there's 3 different ways of rating a knee: range of motion, a meniscectomy, and arthritis. And the doctor might add those all together. Well, they shouldn't be adding them all together. They should be applying Table 17.2 to say which can and cannot be combined. So if the doctor was to look at that, they would either see that the range of motion, that could rate higher than the combination of the meniscectomy and the arthritis, or the combination of the meniscectomy and arthritis could rate higher than just the range of motion alone. But for them to just add them all together is not appropriate use of the AMA guides. So would that be a time when the rater may need to step in and, make a correction? But on formal rating instructions, if they're just telling us to rate this doctor's medical report, it's up to the rater to come up with this, or do we rate something that's actually incorrect if what the doctor's doing is adding those all together? So it just leaves a problem, and this is something that we've kind of talked about as raters since Blackledge has come about, because all of a sudden it kind of ties our hands in some ways, but creates other questions, and we're not quite sure how some of this plays out until we are being cross-examined. Also, as a second part to that, can the rater, do they have the ability to make corrections That's a good question. We might see something that's in the medical report that the judge has asked us to rate. However, that is something that if they are telling us specifically to rate something a certain way, then we would need to go ahead and rate it exactly the way the judge said. This brings up a case that is not an en banc decision, but it was called the Foot decision. And in Salinas, there was a case where the injured worker had carpal tunnel in their right hand. And so the medical report came in, and the only way that the doctor described the impairment was grip loss. Well, you don't rate grip loss for carpal tunnel. So the rater put the rating out at a 0. And that was it, because they did not rate carpal tunnel per page 495, which tells you either rate the median nerve deficit, or you can give up to 5 upper extremity, which would be 3 whole person, or it's 0, but you don't rate carpal tunnel per page 495 for grip loss. So then formal rating instructions were sent out, and the judge did the same thing to rate the carpal tunnel for grip loss. 0. At the time, this was before Blackledge came out, so she put it out as a 0 because according to the AMA, you don't rate it that way. And that was fair and didn't create any waves. But what happened was then the judge reissued their instructions and said, right wrist, rate grip loss. Well, then it's okay because it's now not a carpal tunnel issue. It's just a right wrist injury, and it was rated using the grip loss. And so that was a question. They upheld that and said, yes, that's fine, because the judge wanted this right wrist injury to be rated by the grip loss. It was done. And so there was a question, well, does that mean that we can rate grip loss for all carpal tunnel cases? No, just that one in particular. But that was a way where the judge was able to rework their formal rating instructions in order to get their desired effect.
That Foot case, I think, was before Alvarez and Guzman, but it was, I mean, in retrospect, it's kind of an Alvarez-Guzman case, isn't it?
Well,
Yeah.
well, my recollection of this decision is the following, that when the judge instructed it and the rater had to rate, and it could be upheld on that, but the judge has to have substantial evidence. And if Guzman's not satisfied, you don't rate grip loss. Remember the cases I showed you? Grip loss is not rateable, even because judges can be involved in reversible error. And if a judge says, listen, it's not rateable, I know it, and they didn't satisfy Guzman, and there's no other way to get there, and he says just rate it, well, guess what? That's going to be reversed, right? So that's what she is correct. It was before Blackledge and before the final versions of Guzman. So, but it wasn't that much PD, was it? Wasn't
No,
like,
it was a small rating.
yeah.
and
So that's why it
everything.
didn't go anywhere.
Yeah. So, tools of the trade we use, this is just, we can go through some of this, you already know. Alvarez Guzman, we've discussed already. Here's an example of an Alvarez rating, just where, and we don't see this as much anymore, the hernia table, but they still are trickling through. A taxi driver, 46 years old, low back injury with radiculopathy. The doctor gives it a DRE3 at 10 whole person, but states that due to difficulty with heavy lifting that Alvarez Guzman would apply, and provides an analogy rating to the hernia table 6-9 and gives it a 19% whole person. So the first formula is the strict rating per the AMA guides. It's the DRE3 at 10%, and then it adjusts out to a 14 final PD. The second rating is a rating per Alvarez, and that's with the 19%. You'll see at the end of the impairment numbers 15.03, 0.01, 0.99. If you see a 99 at the end of the rating, that's usually an Alvarez rating. It's an unscheduled rating. It's something that veers off the normal rating for what the AMA would be. So that is the 19 whole person, and then that adjusts out to a 25. DEU, when we get medical reports, we will provide a rating on the strict application of the guides, and then we will provide the Alvarez rating. Sometimes, though, because originally they didn't require the doctors to say they were rating per the Alvarez case, so it was hard at first sometimes for us to determine, did the doctor just make an error in what they were doing? For instance, rating grip loss for carpal tunnel, we would see that a lot in the beginning. or were they using that as an Almarez-Guzman alternative rating? So what we try to do is pull out the information and provide a strict rating per the AMA guides, and then we provide the Almarez or the alternative rating. And actually sometimes there's a third rating because they'll, maybe for instance, the original AMA rating, if this was plantar fasciitis, would be a 0. And then they would say that, and this is actually something that came across my desk, they did the alternative rating, because an analogy rating, since plantar fasciitis was not part of the AMA guides, they analogized it to the altered gait of the lower extremity table 17.5, and they gave it a 7 whole person. But then they felt that that wasn't even appropriate, and they went to chapter 13 under station and gait and gave it a higher rating. I don't recall what the value was, but so they gave we had 3 ratings, because you had the strict application of the AMA guides, you had the analogy rating that the doctor used because there was not a specific rating, that he was analogizing to the altered gait, and then the third was that he felt that wasn't even appropriate and gave the Almarez. So we're seeing all kinds of morphosis of the Almarez and what happens with these medical reports. If this same example here was date of injury of 2013, where previously we had a 14 for the AMA rating and a 25 for the Almarez-Guzman, then in this situation we would have a 15 for the strict AMA based on the 1.4 modifier, and our 25% for the Almarez-Guzman increases up to 29. So just to give you the idea, to remember that for 2013 and more current, there is no FEC of 1 through 8, and we use the 1.4 modifier across the board. So with Almarez-Guzman, we have traditional. Is it a traditional? Is it an alternative rating? Does the doctor intentionally deviate from the guides? Is it a mistake? Are they trying to rate something that they're applying the tables inappropriately? Are they invoking Almarez? Is it an alternative rating that's based on the 4 corners of the guides? And then what are those 4 corners? Because we see all kinds of different things within the AMA guides that are used as an analogy rating, and it doesn't seem like it really makes sense. So really we want the doctors to provide this alternative or Almarez rating, but give us the rationale as to why that's appropriate. And so that's something that's really key. One thing that I wanted to bring up is we talked earlier about the kite decision, and that's something that we're actually seeing at DEU more frequently now. It falls under Almarez, but they're mentioning kite as to why they're doing this additive approach. And so it was bilateral hip injuries. It was 33% for each hip. And when you added them together, which is what the doctor suggested, 33 and 33 is 66. When you applied the combined values table, 33 combined with 33 was 55. And so that didn't make sense. And so the doctor thought that it would be more appropriate to add. And I just am, as a historical type of thing, because I've been doing this again for a long time, and I'm pretty sure that this table that's over here was not even born at the time I became a rater. But the old schedule ratings, when you had opposite extremities, for instance, it would be an additive approach. So as a rater, it makes sense to me. Under the old schedule, if you had one hip was 30, the other hip was 30, together, if you had a bilateral hip injury, it would be 80%. So it would be greater than, and you would run out the one formula. If you had no work above shoulder level, for your major shoulder would be 15, for your minor shoulder would be 13. Together it would be a 40% if you could not do work above shoulder level bilaterally. So for me, opposite extremities, this kite decision makes sense because you have more impairment based on a bilateral injury. Don't listen to me. But, it doesn't make as much sense to me necessarily if there's other body parts, and there could be some overlap and all. But the whole concept of a bilateral injury, opposite sides being injured, you have more disability. So that whole idea of kite was kind of, to me, it'll be interesting to see if that goes any further.
One of the things, Annalise already, she and I already discussed this. So one of the things I'm going to do, because the CompCalc automatically applies the combined value equation, is I'm going to put a little flag in there that if you check it, it won't do the combined value. So you'll have separate ratings. You can then do the math and combine them so that you have an aggregate rather than a combination. Instead of a reduction, it's just additive, and that'll be available in 2016. So. Yeah. Okay. I acquiesce.
You're such a good guy.
Oh yeah.
Okay. Continuing.
Yeah.
on to the
Well, why don't we take a break? But a couple of comments, and then we'll take 15 minutes or so. I just want to be compliant. We need to push through this stuff, but I want to be compliant with the state bar because they do monitor and regulate this whole, putting on a conference, and we all want MCL and specialization credits and QME certification. One of the questions that we had earlier, and I did it off the top of my head, was what constitutes catastrophic, and I told you there's only one definition that I'm aware of. It's on page 41 of your materials. I did include it in there, and it's found at 42 USC 3796B, and that's the only definition that I'm aware of on catastrophic. I don't think it applies. I think my analysis, if you read through that, is probably the better one. You look at all three. You look at the mechanisms of injury, the resulting medical care, and the resulting whole person impairment or residual disability, and determine whether or not it's a catastrophic injury for the purpose of compensable consequence psychiatric injuries. Okay, easy for me to say. Let's take 15 minutes.